It is pleasure to welcome you to the fifth week of our certificate course in Effective Instructing Attorney. Today's lecture focuses on Instructing Attorney, practice relating to District Court and Commercial High Court. But before we begin, allow me to say a few heartfelt words about the remarkable individual who will be guiding us through this subject. Sometimes you do not need to do the introduction from one to other, because either his profile might be too long to tell you, or the person is very well known to everyone by his profession. Yes, he was well known from his student's life at the law college. He achieved first class honors in all 3 years in his law exam, and in the final year he topped the batch. He has excellent knowledge in all 3 languages as well. For the past 11 years, I have had the privilege to knowing and working with him. In every sense, he has proven to be one of the most exceptional resource persons we have had in the honor to collaborate with. Whether it be a seminars, workshops, legal trainings or symposium in Colombo or any part of the island, whenever we are called upon him, he has responded with the hesitation. What makes him stand out even more is not just his broad knowledge, but his generosity and unwavering dedication, despite a schedule filled with a professional commitment. He never say, "I can't." He travels at his own expenses, arranges his own fee to stay, and brings with him not only the wisdom but also meticulously prepared resource material for the participant, all without expecting anything in return. These days, finding such a person is very difficult. His contribution to the legal profession and to the Bar Association of Sri Lanka are testament to what public service and professional excellence look like. In every training session he delivers, there's not just a content, his conviction, clarity, and the genuine passion of uplifting the legal community. So, it is with the immense respect and genuine gratitude that I speak about sir. And sir's profile is indeed very long. I will share it with you all with the recording of the session. In recognition of his exceptional service to the legal profession for well over 44 years, Mr. Arulpragasam was conferred the honor of Senior Instructing Attorney at Law in accordance with the Act number 26/2023 by President Ranil Wickremesinghe. So you can learn a lot from such a great teacher. Don't miss the opportunity. He will answer the question even if you ask any other 3 languages. So he is excellent, because even though it's taught by a Tamil, he did all his studies in Sinhala, so he is well aware of all 3 languages. Now, I welcome our senior instructing attorney, Arulpragasam sir. We are truly honored to have you with us today. It's over to you.
Thank you, Prabha, your generous and the detailed introduction. Good evening to all of you. The topic that I have to address you today, the role of an instructing attorney when he or she practicing in the district court or the commercial high court. So before I commence my lecture, I like to explain who is an instructing attorney. To give an explanation about the instructing attorney, I have to go back to the history of our legal profession. As you all know, Sri Lanka was a British colony during the period of 1796 up to the year 1948. When we were under the British rule, we have inherited many things from Englishmen. Some of them are legal profession and the legal history. In England, the legal profession consists of 2 branches called solicitor and the barrister. Solicitor is the person who gets the opportunity to meet the client and ascertain the problem and retain the barrister to argue the case. Barrister has no right whatsoever to have any direct dealings or communication with the client. In Sri Lanka too, from the year 1801, last 224 years, our legal profession is in existence, and up to the year 1974, our legal profession was consist of two branches called proctor and advocate. To become a proctor, when that system prevailed, you have to get through your O-level exam and an English credit pass in that exam. Similarly, to become an advocate, you have to get through your advanced level exam and an English credit pass in that exam. In the year 1974, then Minister of Justice, Felix S. Bandaranaike, amalgamated both professions into one called attorneys at law. So from the year 1974, last 51 years, everyone who is passing out Sri Lanka Law College called, known as attorneys at law. Although this profession was amalgamated, last 51 years, the division continued. Some of the lawyers who are passing out from law college after 1974 and taking oaths in the Supreme Court as an attorney at law deciding only to have practice as a counsel and having chambers. Similarly, some of the lawyers who are doing only deed work, running officers, filing proxy, not arguing cases. Having said so, there are some lawyers, mainly more than Colombo, in outstation. They are well versed in counseling as well as the instructing attorney in both work. So they are, at times they are much better than the best counsels in the country. So although these two branches were amalgamated, up to date this separation continues. Just to give a simple example, even in the Civil Procedure Code, Section 27 categorically recognizes the instructing attorney, which reads as follows. Section 27, I will just read. The appointment of a registered attorney to make any appearance or application to do any act as aforesaid shall be in writing, signed by the client, and shall be filed in court. Every such appointment shall contain an address at which the service of any process under provisions of this chapter may be served. And in the 27 subparagraph 3 says, no counsel shall be required to be present any document empowering him to act. So this clearly establishes, notwithstanding the fact in the 1974 both professions were amalgamated, division continued. So although the division was continued, up to last year, the lawyers who are practicing as counsel, who reach eminence in the profession, were recognized and they were given, we call a silk or the President's Counsel. So if you look at the Constitution, 1978 Constitution, Section 33, subparagraph 2E, clearly state, to appoint as President's Counsel attorneys at law who have reached the eminence in the profession, have maintained high standard of conduct and the professional rectitude. Every President's Counsel appointed under this paragraph shall be entitled to all such privileges as were hitherto enjoyed by the Queen's Counsel. So the lawyers who are practicing as counsel, who reach eminence, were recognized. Although these branches, the two branches existed, instructing attorney, who at times not only practicing as instructing attorney, counsel, doing the deed work and maintaining officers, and they were not recognized. But first time in the history, I think as Prabha said quite correctly, with the introduction of the new Act number 26 of 23, conferring the honor of senior instructing attorney at law, 5 lawyers were honored and I happen to be one of them. The difference is that in regard to the honoring, giving a President's Counsel as well as honoring as a senior instructing attorney, to become a President's Counsel, the procedure hitherto adopted was you have to make an application. Application will be scrutinized, looked into the merits and demerits of the application, and President grant the appointment as a President's Counsel, and you go before the Supreme Court on a ceremonial sitting, take oath before His Lordship, the Chief Justice. In regard to the conferring the honor of senior instructing attorney at law, the Act says there are a couple of criteria you have to be fulfilled. Number 1, has been in active practice as an instructing attorney for a period of less than 25 years, has reached eminence in the legal profession, has not been found guilty of any criminal offence, has not been found guilty of any professional misconduct. Then it very categorically says, prior to the appointment, there are certain guidelines for His Excellency the President who is appointed. What is the guideline? He has to get the recommendation from His Lordship the Chief Justice, Minister assigned the subject, that is Minister of Justice, and also having got the recommendation only, this appointment will be made. So there the question is, in regard to the honoring, getting the certificate or taking oath, that takes before the President. So in short, the point what I am trying to stress is, although the profession was amalgamated and division continued for the last 51 years, having had the division up to 2024, 2nd of May, only councils were recognized. Now I am glad to inform whoever is working and acting or doing their function as an instructing attorney is an encouragement where you too will be honored. So that is the history or the detail about instructing attorney at law. Why I went in detail? Because when we pass out from Sri Lanka Law College, the oaths that we are taking not as an instructing attorney at law. The instructing attorney at law is a title that we continued as far as the profession is concerned, the act that you are doing. Mainly, whether you are functioning as a counsel or whether you are functioning as instructing attorney, is up to you to decide. But as far as this lecture is concerned, I am simply going on the basis all are attorneys at law. There is no question of instructing attorney or anything, because everybody who is passing out as an attorney at law. So let me get back to the topic. What is the role of an instructing attorney, or a rather attorney at law, when you are practicing as a lawyer? So when a client comes to you and give instructions, one of the two, either to draft a claim, to file an action, or having received a summons to defend the client, what steps that you have to take, whether you are retaining counsel or you yourself is a counsel, what are the things that you have to look into? The first and foremost thing that what you have to look into is jurisdiction, where to file the case. Jurisdiction. The jurisdiction is set out in section 9 of the Civil Procedure Code. According to section 9 of the Civil Procedure Code, there are 4 limbs where you can file action. Number 1, where the party defendant resides, or if it is in respect of a land, where the property is situated, or where the cause of action arose, or where the contract sought to be enforced was made. Recently, to section 9 of the Civil Procedure Code, the amendment was brought in to the first limb, 9A. It is not only where the defendant resides, now you can file action where the plaintiff too reside. Say for example, there is a land dispute. Property is situated in Mathura. Defendant also in Mathura. Normal position, if not for the amendment, it would have been you have to go to Mathura to file a case. Now, it's so convenient, you can file, if you happen to be, if the plaintiff or your client happen to be in Colombo, you can file action in Colombo. So, the first and foremost thing, what you have to look at is, what is the jurisdiction? Having said that jurisdiction is concerned, there are certain instances where the Ministry of Justice, time to time, either expand the jurisdiction or limit the jurisdiction. Just to give a simple example, especially Mount Lanier as well as Nugegoda, those courts are concerned, there is a concurrent jurisdiction. What do you mean by concurrent jurisdiction? If you have to file action in Mount Lanier, if you have filed the action in Nugegoda, there is no problem at all because it has concurrent jurisdiction. Similarly, there are certain instances where the Ministry of Justice, time to time, change the values of pecuniary values, what amount of will fall within this particular courthouse or not. So that is the first question, is jurisdiction. Now the second matter is in regard to jurisdiction relating to divorce action. Now come back to the question of divorce action. The section 9 of the Civil Procedure Code will not apply. So what is the section which will apply? The section what will apply is section 597 subparagraph 1 of the Civil Procedure Code. What does the section 597 subparagraph 1 says? Section 597 subparagraph 1 says you can file action where the plaintiff or the defendant reside. I read section 597 subparagraph 1. Any husband or wife may present a claim to the district court within the local limits of the jurisdiction of which he or she, as the case may be, reside, praying that his or her marriage may be dissolved on any ground for which marriage may, by the law applicable to his or her case, be dissolved. So that is in regard to the matrimonial cases. I like to pose a question to you now, whether in regard to same thing pertaining to the divorce or the matrimonial matters, if a party contract a marriage or get married outside the country, whether the Sri Lankan court has jurisdiction to dissolve or nullify such marriage. To give an example, ex-lady getting married to a gentleman wife in India. They were living together, there is one child by the marriage, marriage didn't work properly well, so she came back to Sri Lanka. Now she wants to file an action. Whether you can file action, can Sri Lankan court grant divorces in regard to the marriage which contract outside the country? The case on the point is Asokan versus Asokan 1 SLR 1994 1 SLR 413. I'll repeat it again. Asokan versus Asokan 1994 1 SLR 413. Interestingly, I who argued this case in the lower court and I lost. Subsequently, I succeeded in the Court of Appeal. The facts of this case are, as I said earlier, a Sri Lankan lady got married to an Indian gentleman in Chennai, and for a short while they lived together well, but there was a child by the marriage. Marriage didn't work well. She came to Sri Lanka and gave me instruction to file action. Husband, of course, did not contest, but still for all, court dismissed my action on the basis that the Sri Lankan court has no jurisdiction. But the reason was the learned district judge followed an old judgment called Lamasuria versus Lamasuria 1 NLR 160. I'll repeat it again. Lamasuria versus Lamasuria 1 SLR 1 NLR 160. The facts of this case are Sri Lankan gentleman who was a civil servant who went to England got married in England to a French lady. And when they got married, they came to Sri Lanka, they lived together, things didn't go well. Then he was living in Mathura, filed action in Mathura court to dissolve the marriage. Wife took up the objection. Sri Lankan court has no jurisdiction because the marriage was contracted not in Sri Lanka, outside Sri Lanka, and therefore court has no jurisdiction. So in this case, court held, because as at the time of this action was filed, the civil procedure court was not in existence, but was in existence general marriage ordinance. So in terms of the general marriage ordinance, as at that time, the law prevailed was Sri Lankan court only could grant a divorce or an annulment or a dissolvement of marriage only within the territorial jurisdiction. So if that has taken place within the territory only, divorce can be granted. And going on that judgment, learned district judge before whom I argued the case dismissed the case. Finally, when I went in the appeal, court did not overrule the judgment. What court said is, they distinguished, because this was a Privy Council judgment, court distinguished the judgment, the earlier one in NLR 160, and said law prevailed at that time was general marriage ordinance, and therefore that judgment was correct. But now section 597(1) civil procedure court is in existence, and therefore court has power and overturned the district judge's judgment and granted the divorce. So once again, the point what I am trying to stress is, if anybody who contract a marriage outside Sri Lanka and come back to Sri Lanka and file an action to dissolve such marriage or to nullify such marriage, whether the Sri Lankan has court jurisdiction, answer is yes. Case is Asokan versus Asokan 1994 1 SLR 413. Now I'll pose the question the other way. That is, now you get married in Sri Lanka, you go to a foreign country, and there your marriage don't work well, you file a divorce action in that country. Now can Sri Lankan court accepts the divorces which are granted outside the country? I'll pose the question again. Earlier question was whether the Sri Lankan court has right to dissolve a marriage which was contracted outside the country. Answer is yes. I gave you the authority, Asokan versus Asokan. Now it's a reverse. A Sri Lankan party who get married in Sri Lanka, go abroad. Both are living maybe UK, USA, Australia, New Zealand, some part of the world, file action in the respective country, get a judgment. If such judgment is valid, up to very recently, that judgment, the court did not accept, said no, that's not a competent court, and therefore Sri Lankan, we did not recognize. Now the new law has come in, Reciprocal Recognition, Registration, Enforcement of Foreign Judgment Act number 49 of 2024. I'll repeat it again. Reciprocal Recognition, Registration and Enforcement of Foreign Judgment 49 of 2024. In that section 6 subparagraph 1 very clearly said, where upon registration of a foreign judgment for the dissolution or annulment of marriage or separation of the parties of a marriage under section 5, it appears to be registered in the court shall such foreign judgment given inter partes, the registering court shall pronounce a declaration recognizing such judgment in Sri Lanka, or such foreign judgment as obtained ex parte, registering the court shall issue such notice to the other. So there are two prerequisites. What have you got to prove? First and foremost, if that in that country the divorce was granted inter partes with the participation of the other side, there is no issue. All what you have to do is file action in terms of the particular this act, get the judgment registered. That's the end of the matter. That will be recognized, almost given as in Sri Lankan court, because it says very clearly, section 8 paragraph, such declaration shall have the effect of such foreign judgment for the dissolution and annulment of marriage or separation of the party recognized as it has been issued in the competent court of Sri Lanka. So what is the procedure that you have to follow? In terms of section 6 subparagraph 1 A of the said that it has to be an inter partes. Both parties have participated. So if it is an inter partes, all what you have to do is get the entire case record of that country, papers that you have filed, the dissolution or the divorce what has been granted, register it here. You have to get certified copies, register it here. Upon the registering, there is no necessity even to hear the other side. Court will accept it. Why? It's an inter partes, there is nothing to look to. On the other hand, if it is an ex parte judgment, in such event, it won't be straight away registered. Court will accept, issue notice to the other side, show cause why this judgment should not be registered. So that is the procedure to be adopted in regard to the marriages which are dissolved outside the country, parties who got married in Sri Lanka. Now in that also there is a restriction. Such judgment, there is a prescription period. If you have got a foreign judgment, in terms of section 4, subparagraph A, within 10 years from the date of the final judgment, along with a certificate issued by the relevant authority of the original court authenticating such judgment. So there is a time period prescribed. After that 10 years, you can't register a judgment which has been pronounced in a foreign country. Now the next thing, based on the same issue, I will pose a question to you there. X and Y married, divorce granted, nice I entered, absolute entered. Now the question is, as at the time husband filed action, say their wife was living in adultery. There are 2 children by the marriage. Wife decided not to contest the case because she knows very well she will not succeed. Now she got the divorce, children are with the husband, legal, physical custody, everything given to the husband. Now wife discovered husband is now married, having another child by the second marriage, and he's ill-treating. Now the question I'm posing to you is, once a decree nisi as well as absolute grant and not contested, can the wife at this stage, and she was living in adultery at that time, now still she is not married, her position is, can I have my children back? Can I have more access to the children? No doubt I did not contest due to the circumstances prevailed at that time. Now I want my children back. Whether the Sri Lanka, whether our court has, whether we have jurisdiction to entertain that kind of application or a thing after the marriage is over. Answer is yes. It is set out in section 622 of the Civil Procedure Code, which reads as follows. 622, the court, after a decree absolute for dissolution of marriage or decree of nullity of marriage, may, upon application by petition on summary procedure for the purpose, make from time to time all such orders, provision with respect to the custody, maintenance, education of the minor children, the marriage whose parents was the subject of the decree or placing such children under the protection of the said court, might have been made such degree absolute or decree and such interim orders as aforesaid. Now the question arises here, being a wrongdoer, is that lady entitled to? Answer is yes. The case on the point is 46 NLR 464 Blanche Ainley versus Herbert Boyce. BLANCHE Blanche Ainley ANLAY versus Herbert HERBERT Boyce 46 NLR 464. It's read the facts of the case. An application made to court, although the person at whose instant divorce proceeding had begun absent beyond the seas, provided that at the time of the application was filed in court, he or she was resident in Ceylon. The important point is the fact that the applicant was the guilty party in the divorce case is not per se a good reason for the refusing the application for access to children. The paramount consideration is the interest of children. I'll repeat it again. The fact that the applicant was guilty party in the divorce case is not per se a good reason for refusing the application for access to the children. The paramount consideration is the interest of the children. So as an upper guardian, court always looked into the best interest. It's not a question of luxury. It's not a question of wealth of the person or how high profile or powerful in the society, with whom the child will be happy for the child welfare and the benefit, who is the better person, whether mother or father. As upper guardian, there are instances where the children are taken from the natural parents given to grandparents. There are instances where I have done several cases where a child was taken from the natural mother and given to the stepmother. And there are instances, authorities, where the children are taken from the parents' custody and given to the convent or to a third party for the benefit of the children. So the golden rule is a best interest of the child as upper guardian, court always thinks. Now that is in regard to matrimonial action. Now comes to the question of testamentary action. Now don't forget the fact all these what I am discussing now are still under the one limb called what? Jurisdiction. When a client comes, retains you to draft a plan, depending on the nature, how do you ascertain the jurisdiction? Now come back to a question of client coming to you to file a testamentary action. So in regard to a testamentary action, once again, where the jurisdiction you have to look at. Section 516 of the Civil Procedure Code says, in regard to the jurisdiction, if a person die with a will within a period of 3 months from the date of finding the will, you have to file action where the death took place, where the deceased property situated, or where the petitioner resides. Those are the one of the three limbs where you have the jurisdiction. Similarly, when a person within a period of 3 months from the date of finding the will. Next question. Section 525 of the CPC, when a person die without a will, in a testamentary action, has to be instituted within 1 month, once again, the same way where the death took place, the jurisdiction, where the death took place, where the deceased property situated, or where the petitioner resides. Now the next question is, that is all in regard to the testamentary action, we are in Sri Lanka. Now very often we come across now with the current situation as well as last several years, a lot of Sri Lankans have been migrated all over the places. So there are UK, Canada, Australia, New Zealand, various places. Now although they have migrated, they have their properties in Sri Lanka. Now the question arises, what happened when they, prior to the demise, the person concerned leaves a will in regard to the properties in Sri Lanka. Get it properly what I will explain to you. Now here is a person, Sri Lankan citizen, not taken the citizenship of other country, and living in England. Quite a lot of wealth in Sri Lanka. So prior to the demise, lot of properties. What they have, they bequeath and they given to various children, maybe their kith and kin. Addition to the fact, appointed the person as an executor. Now, what can we do with a foreign will? Do you get the point what I am trying to say? Sorry. The question I am posing to you is, now, if a person, Sri Lankan, who lives abroad, who has quite a lot of wealth in Sri Lanka, prior to the demise, left a will. In the will, a lot of properties have been bequeathed. Now, where do you file this case to prove the will? Obviously, will is executed by a notary or a solicitor in that country. Now, can you prove this here in Sri Lanka? No. What have you got to do? You have to file action in that respective country and prove the will. And now again a question. Assume you prove the will, you get the foreign probate. What can you do here? You can't do anything. So that is the very reason where there is a specific provision in the Civil Procedure Code, section 554, subparagraph U. What does the section 554 subparagraph U say? Sealing of a foreign probate. If a person living abroad left a will, died testate, in regard to the Sri Lankan property, in terms of section 554 subparagraph U of the Civil Procedure Code, you have to reseal the file action, reseal the foreign probate. What do you mean by resealing a foreign probate? Once you get the will, once you get the entire testamentary case, you bring to Sri Lanka, file a testamentary case in Sri Lanka in terms of section 554 subparagraph U of the Civil Procedure Code. All what you have to do is you have to file a petition, you have to file an affidavit, last will, death certificate, and give the entire details of the property of the schedule. Having given that, you request the court to reseal. There is nothing to prove the will. Why? Will is proved in that country. So once you file the action to reseal the foreign probate, the court will accept the papers and order only one instance, not twice, to publish in the 3 newspapers: Sinhala, English, Tamil, that is basically Daily News, Dinamina and Thinakaran paper once. There can't be anybody who is filing objection because these are bill proved in the country. All what they have to do is basic procedure will apply in regard to the normal testamentary case. So no sooner publication over, there can't be any objection. You file the normal inventory, final account, and close the testamentary case. So in regard to the testamentary case, that's the procedure if a person died, testate, leaving a will in a foreign country. Now the next question I am posing to you, what happens if a person, 2 people, leave a joint last will? I'll give you an example. X and Y, husband and wife, both are executing a last will. In the last will, X says, if I die, entire thing should devolve on my husband, Y. Y says, if I die, my entire property should devolve on my wife, so and so. Having said so, X and Y, husband and wife, both are saying, when we are no longer, that should devolve on the Z. Now the question arises, X died. Now X property is the one going to devolve on Y in terms of the joint last will. The question is, should Y file a testamentary case to prove the will? Why? It's a joint last will. Or should he wait upon till that does it automatically devolve on? Answer is no. If X and Y execute a joint last will, if the last will says upon the demise of X, it goes to Y. If the will, it says if the Y dies, it devolves on X. Or if X and Y both die, if it devolves on Z, in such event, upon the demise of each person, will has to be proved. Now, for example, X says my property upon my demise should go to Y. Now X died. Y should file a testamentary case. Why? To get devolved on a testamentary procedure. It has to be administered. Not automatically it won't devolve. So it has to get administered. Similarly, when Y died, what happened then? Now X is dead, now Y is dead. Z has to file action. He said has to proceed to prove the will again. Why? If X and Y die, only he said will get it. So basically, the last will of a joint will has to be proved on 3 occasions why each person, the property should devolve. If X died only, Y will get it. If Y die only, Z will get it. So each and every person death, although it is a one last will, we call a joint last will, it has to be proved on 3 occasions. Back again, I will repeat, in regard to the all these matters where we have decided testamentary matters are concerned there. Now the next issue will arise in regard to the commercial transaction. Talking about the commercial transaction commenced or the Commercial High Court commenced with the Act number 10 of 1996, and in terms of that, the cases which are falling within the category of a commercial transaction are which value of the actions are well over 50 million, or the transaction falling within the scope and the ambit of Act number 7 of 2007 Companies Act. Now, for example, winding up cases, dispute between shareholders and directors, arbitration cases, etc. Now, there are instances at times when you are not sure about the jurisdiction. Now, say for example, some company issue, but in regard to monetary transaction, you are not sure whether it is a commercial transaction or not. So in such event, what is safer is for you to file an action in the district court. If you do file an action which should have been filed in the district court, in case the other side raised the objection, the case can, in terms of section 9 of the Act, case can be transferred to the Commercial High Court. If a case due to be filed in the Commercial High Court has been filed in the district court, if an objection taken by one party, in such event, in section 9 of the Act number 10 of 1996 Commercial High Court, case will be referred to the transferred to the Commercial High Court. In such event, no prescription will run. If a case filed within the stipulated period of time, normally before prescribed period at the time of the transfer of the case, the time period has left, no such prescription is applied in terms of section. So the point that I am trying to test is, if there is any doubt, if there is any question whether it is a commercial transaction or not, it is always safer you file action in the district court. Once you file an action in the district court, other side may or may not. If they are not taken, no problem. If they have taken, what happens? It won't get dismissed. It will be transferred. Sometime the question may arise at the time of the transfer, the course of action may have prescribed. Doesn't matter, because the prescription runs concurrently from the date that you filed action in the district court. So commercial transactions are value is above 50 million. Transactions falling under the Companies Act, such as winding up cases, disputes between shareholders and directors, arbitration cases, are coming in the Commercial High Court there. So next is, all these are, now we are talking about the jurisdiction. Now back again, still we are under the jurisdiction. The next question in regard to the jurisdiction is in regard to the liquid claim. Now talking about the liquid claim, the liquid claims are checks, bill of lading, promissory loan. The section that we are dealing with, that is chapter 53 of the Civil Procedure Code, or section 703. So these cases are not normal cases. This is, you call a not regular action. These are like summary procedure. What do you mean by summary procedure? You file action, plaint, affidavit, and the document sued upon. It can be pro note, it can be a bill of lading or check, whatever there. So once you file action, like a normal case, no summons will be issued. This summons under particular format called Form 19, where it specifically says, so in a normal summons, what do we say? Action filed by so and so, you are required to appear before court and answer on such and such a day. If you do fail to answer, case will be fixed for ex parte. Nothing of that sort here. Here it is categorically state that in terms of section 19 or the Form 19, chapter 53 or section 703, it says action filed against you, to ask him for so much of damages, so much of capital with interest. You have to show cause why the relief claimed in the summons should not be granted. If you fail to comply, there is no question of ex parte judgment. Please understand, it is judgment. I'll read the relevant section, section 704 of the Civil Procedure Code, which says, in any case in which the plaint and summons are in such form, respectively, the defendant shall not appear or defend the action unless he obtain leave from court as herein after mentioned, so to appear and defend. In default of his obtaining such leave and appearance and defences in person, the plaintiff shall be entitled to decree any sum not exceeding a sum mentioned in the summons, together with the interest, the date of the payment, such cost, and the court may allow time to amicable. So the important thing is, be cautious. Sometimes some of this, when you are practicing in the district court or commercial high court, this problem happen. You receive the summons. You don't look at it as a chapter 53 case or action filed under summary procedure. You come on the returnable date and tender a proxy and move for a date, which you can't do. Why? Section says very clearly. So you have to read the summons carefully. Summons says you have to have leave to appear and defend. So on a summons returnable day, if any lawyer for the other side appear in court, get a date, request a date to file answer, you can get a judgment straight away. No ex parte judgment. Now the next step is, how does this work? Now I explained you the practical side. Now you offer the plaintiff, you know, you have to file a plaint, affidavit and documents sued upon them. Now what has the defendant got to do? Now we receive a summons of that nature. So the client come and say, sir or madam, there is no money transaction at all. This was a money lending transaction. I gave this check as a security deposit. There was no financial transaction. These are ongoing business we are doing. This check is no this thing at all, and that is the reason it got bounced. So that's a good defense. And also provided, if there are correspondent to back up and to say that I gave this security as check and don't deposit this check, don't present this check because I have paid part payment, only balance is due. So that shows some correspondent to the effect to show that it is not a check given on a valuable consideration. The cardinal principle or the main rule in regard to the check cases are, it has to be given on a valuable consideration. The checks which are given as security cannot be used for the purpose of suing the person. So if the defendant could prove, or the other side could prove, that this particular document, the particular check was not given for a valuable consideration, if he can be backed up by some correspondence, emails or some kind of a documentation between both parties, court can do three things. Once you file papers for leave to appear and defend, first step, if court is not satisfied at all with the defense and it's completely no defense has been established, in such event, court will order deposit the entire amount of money before you file answer and give a date, maybe 1 month. So within that 1 month you have to deposit. If you fail to deposit, judgment will be entered, no ex parte. The second thing, now there are instances other way, where there is something what defendant says also right, but plaintiff says also somewhat right. So the court is not 100% convinced, somewhat, say for example 50% convinced, 50% not convinced. So court, see, having gone into the matter, there is a matter to be looked into, but however, you have to deposit 50% of the amount prior to filing the answer. That's a second scenario. The third one, court looks at it and says the plaintiff has completely misled the court, and this is not a check given valuable consideration, basically a blank check given, a signature is in one color, the dates and the body of the thing has been filled in different color. That clearly shows there is some manipulation by the plaintiff. There is a clear defense, plus add to the fact there are correspondent to show that not to present the check, and he has given issued several letters and the email, and also after issuing the check he has given some part payment, not given credit, he is showing proof for that. So court is fully satisfied. In such event, court can turn back and say, no, I am not happy at all with the way that the plaintiff has presented the case, and therefore I give unconditionally no money to be deposited straight away there. So come back to liquid claims, understand the situation is we have to be very careful, because on the summons returnable date, you have to file papers from when within 14 days from the date of the receipt of the summons, not the returnable. So it is very material when was the summons served. From the date of the summons, within 14 days we have to serve, we have to file paper. So having filed papers, court can do three things: satisfied, either full conditional, grant, say that full amount be deposited prior to filing the answer, or 50%, or fully unconditional leave. So those are the steps what the court could do in regard to a summary case. So be very cautious if you are for a defendant on a summons returnable date. Don't wait till the returnable date. Find out from the client when was the summons served and to take steps immediately. Then next question is in regard to the defamation case. So some people make mistakes in regard to defamation case when amount is 1 billion, 500 million, whether the court, no, irrespective whatever the value is now, not now, throughout, it is where the earlier in terms of section 9 will apply in regard to defamation cases, irrespective of the value, it is in the relevant district court, either where the plaintiff resides or the defendant resides. Just because of it defamation cases, just because of the values are very high, running into millions and billions, cause of jurisdiction is same jurisdiction, district court of a person where the plaintiff or the defendant reside in terms of section 9. Then the other issue is, recently there was a little controversy judgment, SC Appeal 29/2016, in regard to the Civil Appellate Court jurisdiction. Now the question is in regard to Civil Appeal High Court. Now for example, Colombo District Court grants gives a order. Now against the Civil Appeal Court order, the District Court give an order or a judgment in the order. District Court gives an order, in Colombo District Court gives an order. Now where do you appeal? Which court? It is a civil appeal. Generally the law says it's a Civil Appeal High Court of Western Province, Holden in Colombo. All these are Western Province Civil Appeal High Courts are there. Holden in Colombo, Holden in Mount Lania, Holden in Oisavin. Now the question is, are we restricted to go to that particular court, or whether we can go the entire vicinity of wherever the court what we feel we should go? In this case, normal practice hitherto all we adopted, if it is the order given by Colombo District Court, if we go to the Civil Appeal High Court of Colombo. If it's order given by Mount Lania Court, we file papers in the Civil Appeal High Court of Mount Lania. Similarly, each respective area, if it is Negombo Civil Appeal High Court. But in this court gave a very wide interpretation and said, SC Appeal 29/2016, their court held the very wide jurisdiction, gave the interpretation of what do you mean by Western Province there. So when you say Western Province, Holden in particular there, Civil Appeal High Court mean the entire area, it is not there. So basically, if there is an order given by the District Judge of Colombo in District Court, against that order, we can even file an appeal, the leave to appeal application or revision application in Mount Lania, or we can file it in Nigam, wherever the entire Western Province. So all this time, I discussed one matter with you, namely jurisdiction. In terms of the jurisdiction, as I am concluding the jurisdiction part of it, I will just say quickly. Number one, when you come to client to meet you, whether you offer the plaintiff or the defendant, look at the jurisdiction. Jurisdiction is set out in Section 9, and recent amendment to Section 9 is Act number 43 of 2024, where an amendment has been brought in. Not only the defendant party reside, you can file action where the plaintiff resides also. The second issue is, as I said, time to time, Minister can enhance, the Minister of Justice can enhance the jurisdiction and or have a concurrent jurisdiction. Then I spoke about matrimonial action. Matrimonial actions are specifically set out. Section 9 doesn't apply. Section 597 subparagraph 1, I said very clearly whether Sri Lankan court has jurisdiction to grant a divorce in regard to a foreign country marriage. Yes, case on point of Asokan versus Asokan, 1994, 1 SLR 413. And similarly, the other way about, where whether we accept a judgment given by a foreign court in Sri Lanka? Answer is yes. I said reciprocal recognition of registration of enforcement foreign judgment 49 of 2024 Act is there. Then and also within 10 years you have to file the case. Then the next issue is whether after degree nisi entered, after absolute entered, whether court has jurisdiction to entertain any application for custody, maintenance. Answer is yes. Blanche Ainley versus Herbert Boyce 46 NLR 464. Then those are in regard to matrimonial matter. Then in regard to testamentary cases, I discussed with you, when a person die with a will within a period of 3 months, you can file action where the death took place, where the property situated or the petitioner reside. Similarly, in terms of section 525, when a person die without a will, same jurisdiction applied, where death took place, this is property situated or petition reside. Then came to a question of a resealing of a foreign probate, namely when a person die in a foreign, Sri Lankan, die in a foreign country, leaving properties in Sri Lanka, that particular property, what are we going to do in regard to the last will? That last will has to be proved in that country. It has to be sealed, foreign probate has to be obtained, foreign probate has to be resealed in Sri Lanka. Similarly, when there is a joint will, if husband and wife giving it to vice versa for themselves or giving it to a child upon their demise, on not two occasions, on 3 occasions, will has to be proved there. Then jurisdiction pertaining to commercial high court, the value of the action 50 million or above, it is a commercial high court. Transaction following Act number 7 of 2007, winding up cases, shareholders and directors cases, arbitration cases are in the commercial high court. Similarly, if you are not sure about the jurisdiction, safer, advisable, file action in the district court, objection taken in terms of section 9, that can be transferred to the correct court here, the commercial high court there. Then likewise in liquid claims, I said checks, pro note and bill of lading, action filed under summary procedure. Don't wait till the returnable date. Within 14 days from the date of the service, you can do that. Now the point what I am trying to stress is, now these are the matters where lawyer has to look into. Now say for example, you don't look at the proper jurisdiction, file, action will be dismissed. Action will be dismissed. Similarly, when you are for the defendant, you can take up the objection, well, this jurisdiction not falling within the gap, action can be dismissed. The danger will be if you are not following this procedure. I am the chairman of the professional disciplinary committee. There are series of complaints due to this kind of issues. Cause of action, they have not checked the exact jurisdiction, action filed in the wrong place, and owing to that now when they discovered with the objections the other side, it is time barred. So you have to be very cautious. So when you are for the plaintiff, when you are appearing for the plaintiff or the defendant, you have to be cautious to, and you should know these steps there. Now all this time I discussed, then also I discussed defamation cases irrespective of the value where actions are filed in the relevant district court, not in the commercial high court due to the value. Similarly, in regard to the jurisdiction of appeals, interim appeal like a leave to appeal or a revision application, notwithstanding the fact that it is granted by a particular court, you can go to the respective Western province jurisdiction. You're not confined to the particular court. For example, if an order given in the Colombo district court, you need not, there is no necessity only for you to go there. If you are more comfortable to be in Mount Lania or any other court, you can find these things are there. But having said so, in regard to the divorce cases also, I must say one thing. Section 597 subparagraph 1 clearly says where the plaintiff or the defendant reside. There are instances, I am saying with responsibility, counsels who are not practicing within the area where the husband or wife both reside. Now say for example, husband is coming fall within the jurisdiction of Kaduvela court, other one is coming in Homagama court. The law is saying, look, I don't practice in neither Kaduvela nor Homagama, I am in Colombo, shall you file action in Colombo? Never to agree what happened, and don't file action according to the convenience of a counsel. Resulting position will be when the other side takes up jurisdiction, action get dismissed. So don't look into the convenience of a counsel, follow the law. In terms of section 597 of paragraph 1, it is where the plaintiff or the husband reside, not the where counsel is practicing. So there are instances It has happened in many cases where I myself has taken certain jurisdictional objections, they have succeeded. When I asked the lawyer for the other side, he said, sir, this is what happened, junior lawyer. The client insisted he want to get this particular counsel. Counsel said he is not coming to any other court, only Colombo, I filed it here. Other side took up the objection, proved in that respective address that particular plaintiff is not residing, got dismissed. So, jurisdiction in terms of 597 subparagraph 1, husband or wife, not counsel jurisdiction. Right. Now, all this time in regard to the jurisdiction. Now, let me get into the second point, most crucial point. So, when a client comes, either you are filing, drafting papers or drafting objection or answer, looked into the first matter, jurisdiction. Now, let's talk about the second point, cause of action. Now, when you talk about a cause of action, say in regard to a divorce, section 19, subparagraph 2 of the General Marriage Ordinance, it clearly says there are 3 grounds for divorce. Number 1, desertion. It could be malicious desertion or a constructive malicious desertion. Number 2, adultery after the marriage. Number 3, incurable impotency. Now, talking about desertion, what do you mean by desertion? The desertion means the party who leaves the matrimonial home is guilty of the offense. Constructive malicious desertion is you make your spouse miserable and owing to your conduct, spouse was compelled to leave the thing. Now, when you take about these divorce cases, there are very often we come across very nice, quite interesting facts are there, very juicy informations are there. So, take a divorce claim, they simply say, had an affair, dating for so many years, went here and there, all these places, and then what happened in the first night, thereafter how he hammered, what are the, but important ingredient, what is the ingredient? When did the desertion take place? It won't be there. So those are all prolix. If you do that, in terms of section 46 subparagraph 2 of the Civil Procedure Code, your action will get dismissed. So ensure, when it comes to a question of divorce case, all these stories, interesting, very nice to read, but come back to the most crucial thing. What is the crucial thing? You have to put basically the cause of action. In regard to, say, desertion, when did the desertion occur? You were compelled to leave home, that is the constructive desertion. When did it happen? Did you make a police complaint? What happened? Were you hammered on that day? All the details have to give it. So no point of, nobody is interested what happened. You can ever, what happened in the first night, whatever, all that is immaterial. Important thing is in regard to the matter. When did you get married? When did you form the matrimonial home? What are the matters in issue? When did the desertion took place? Or when did the constructive desertion took place? That is in regard to desertion. Now there are instances even in regard to adultery. What does the law say? Section 19, subparagraph 2. Adultery after the marriage. Now most of the plaintiffs, what do you see? He was carrying on with several, the wife is making allegation, man is carrying on with several men, naming X, Y, Z, college times, there's school, these people, college time, so and so, now working place, all that you knew very well prior to the marriage. And you knowing very well only you got married. Then no point of covering all that, because law says in terms of section 19 subparagraph 2, adultery after the marriage, not prior to that. And therefore it's immaterial, pleading or useless, all those pleading. Don't put prolix, actions will get dismissed. Third one, incurable impotency. Incurable impotency, but there are certain things where with interval. So if it is incurable only, it will happen because there are parents, I am aware, knowing very well their son is important, they give it in marriage, they are thinking that after the marriage, well, it will succeed. But the fact is that you have to specifically plead that it is an incurable impotence. So important thing is cause of action there. Now, in regard to the divorce, especially the drafting answers, you have to be very careful, because sometimes what happens in the plaintiff, if somebody is drafting a very crafty plaint, say the plaintiff reside, cause of action arose, all that on the one paragraph. So there are instances, if you are not sharp, if you are not vigilant, what happens, you simply thinking it is only the jurisdiction, you admit, but you don't know where the cause of action also pleaded. There were instances where I have taken quite a lot of advantage on that. Plaint consists of everything. The plaintiff reside, cause of action arose, all in one paragraph. So if you are not sharp enough, if you do admit the cause of action, then nothing. On a trial date, shouldn't you say, you start raise a admission, say that cause of action admitted. Other side says, no, I never admitted. I said, look at your answer, paragraph such and such. You have admitted the cause of action. That's the end of the matter. That's the end of the matter. Then sometimes in a land action where you admit the cause of action, then the entire burden shift on the other side. You have to prove that. So when you draft answers, you have to be very careful. You have to take a lot of precaution. Then all this is in regard to the cause of action. Now the next one is when you are drafting a claim, the next matter what you have to look at is to identify the defendant. What do you mean by identify the defendant? The meaning of identify the defendant means against whom you are filing action. If it is an individual, there is no problem. You can say Mr. X. So he is a physical person, so you name him, there is no problem. There are instances where you file action against a sole proprietor. So when you file action against a sole proprietor, you have to name him. How do you name a sole proprietor? When you name a sole proprietor, you have to say Mr. X carrying on business under the name, style and firm of such and such. So if you do when you are going to sue a sole proprietor, if you don't only name him, or if you put only the business name, your action fails. So if it is Mr. X carrying on business under the name, style, firm of, put his name there. So when you are filing a plaint against a sole proprietor, you have to specifically name him and also to give the details about his business. Similarly, when you are for the defendant, when you are filing a proxy, when you are defending the action, you can't just put his personal name and do. You have to get the particular sole proprietor seal and then sign. Why? He kept signs in his capacity as a sole proprietor, not as Mr. X. He is Mr. X, correct. Mr. X is carrying on business under the name, style and firm of such and such. Then similarly, you talk about a partnership. Now say ABC carrying on business under the name, style and firm of partnership such and such. So when you file action, you have to name all three people. A, B, C carrying on business under the name, style, firm of such and such. So that is important. Otherwise, it's not a legal person. Other side can take up objection and say, I am objecting. There is no legal person called, now say for example, X, Y is said carrying on business under the name. So instead of naming them as persons, you put the business name and file action. Business name is a non-existing person. There is no say partnership. Say that X and Y partnership. There is no X and Y partnership existing without people. So important thing is when you are filing an action against a partnership, 1, 2, 3 carrying on business under the name, style, firm of such. Similarly, when you are filing an affidavit or when you are filing an proxy for the defendant, you have to specifically get the partnership seal and say so and so carrying on business under the name, style, firm. That is important. The third one is when a limited liability company. When you are filing action against a limited liability company, all what you have to do is you have to name the company and say this is so and so. So back again I will explain. If you are filing an action, this is to identify the defendant. How do you identify the defendant? You identify the defendant. If he is a physical person, no issue, Mr. So and so or Mrs. so and so or Miss so and so, no problem. If it is a sole proprietor, you have to specifically say Mr. X, sole proprietor, carrying on business under the name, under the style, under the firm of such and such a place as such and such an address. Then you have to name the person. Similarly, if there are 3 partners, you have to name 1, 2, 3, all 3 partners. You have to name them and say so and so, so and so, so and so, carrying on business in partnership at such and such a place. Limited liability company, same. Now the next question will arise. You have to file action for and on behalf of a minor. How do you file action for and on behalf of a minor? So when you are, say for example, ex-father met with an accident, died. Y is living, there is a minor child. So now they want to sue the company or a property, the vehicle belonging to a company, with the one knocked off. Now how do you file a case? It's set out in section 476 and 477 of the Civil Procedure Code. When a minor is a party, how do you file a case? Section 467. Every action by a minor shall be instituted in his name by an adult person who in such action shall be designated in the plain. The next friend of a minor may be ordered person to pay cost and debt. Next one. Every application to the court on behalf of the minor shall be made in his name by his next friend or his guardian for the action and shall be so expressed to be made there. Now, how does this practically take place? How we file action on behalf of the minor? First and foremost, you have to file a thing called a curator CG case. You file a case, petition, and affidavit, set out. X was this minor's father. He died. Now you must have a person who is come forward as a next friend for him to file the case. He's the one who files, say mother's brother, uncle. He files and say, this is my nephew, and my so and so brother-in-law died in an accident, and this is what happened there. So therefore, there is now necessity arisen to file a case. So you file a CG case, curator guardian case, and appoint himself, the particular uncle, as a next friend for the purpose of instruing. So you file a petition, affidavit, set out why the action should be needed to be filed, and annex a copy of the proposed plaint setting out there. So normally in a case of that nature, that uncle's evidence will be led. He has to give evidence, and child's birth certificate, father's death certificate, proposed plaint, all that court will peruse and appoint a person as a next friend. Now you file an action in the district court. How do you do? So and so minor represented by the next friend who was appointed in such and such a case. So this is how it happens. So basically that uncle of the minor child step into the shoes of the minor, file the action. That's how you file section 476, 477 of the Civil Procedure Code. Now the next is what happens. Back again, now this is in regard to identifying the defendant. Now you want to file action against a club. You are a member of a club. Some injustice occurred to you. You want to sue the club. Club is a very unincorporated body. There are numerous members are there against whom you are going to fight. Or there is a political party whom you are maybe say a member of a certain provincial council. They have show cause to say that they are going to remove you from your membership. You want to go to court, get a court order restraining the particular political party, removing you. So what you should do? You can say you want to get an enjoining. So what the application there is, section 16 of the Civil Procedure Code very clearly says what steps to be taken in regard to an unincorporated body. Where there are numerous parties having a common interest in bringing or defending action, one or more such parties may, with the permission of court, sue or be sued, may defend in such action on behalf of all parties so interested, but court shall in such give at the expense of the party applied there. So what you should do, say for example, a political party is trying to throw you out of a particular position that you are holding. So you can go to court, say recognized political party, you go to court, file action and ask for a court order restraining the particular party leadership, whoever not to. There in the same action, you file a petition and affidavit. In the petition and affidavit, make a section 16 application and inform court this is an unincorporated body, and therefore to sue for and on behalf of the particular political party, I name party chairman, party secretary, permit me to add them as defendant in place of the defendant to do. So court, before you support the application for enjoining order, what you should do is you support that application, get permission in terms of section 16 to sue the particular political party. So court will allow you first application is allowed Section 16 application is allowed for you to be the to sue for and on behalf of the political party, and then what happens is thereafter the political party, then court will grant the enjoyment. So not only that, now the question will arise how the public at large will get to know that such and such members have been allowed to be named as defendant. What the court do is generally, court will say in 3 papers in Sinhala, English and Tamil to be published in the newspapers, giving full details and say so and so Mr. X filed action against such and such a political party and has sought permission in terms of section 16 of the Civil Procedure Code to add to sue so and to bring party chairman and the secretary foreign as defendants in the case, and therefore court hereby grant permission. If anybody interested can come. So apart from appearing in the newspapers, it will also exhibit in the party, their head office or headquarters or wherever they are. So that is how in regard to a unincorporated body. So back again, I'll quickly tell. First thing, we discussed about the jurisdiction and details. Then also I spoke about cause of action. Then also next is identify the defendant. Now in regard to identify the defendant, as I said earlier, number 1, in regard to individual, if he's a physical person, no issue. Number 2, in regard to a sole proprietor, you have to name mistakes, carrying on business as a sole proprietor. Next one, if it's a partnership, A, B, carrying on business under the name, style, firm, partnership, if it's a company. Then if it is a minor, in terms of section 476 and 477 of the Civil Procedure Code, you have to file action through a person who comes forward as a guardian, and he will be coming as a next friend. First you file a CG action, get court permission. Having got the court permission, thereafter you proceed to file the action. Unincorporated body, section 16 of the Civil Procedure Code categorically state what steps you have to take. So those are the things to be done. Identify the defendant. Now the next step is, there are instances where clients come and retain you and they won't tell. The cases are prescribed. Now, for example, there are prescription ordinance, section 5 very clearly says that there are whatever the wrongdoing, whatever the cases to be done, everything there is a stipulated time period. If you pass the time period and do, then there will be issue. Quickly take it down in terms of the prescription ordinance, the following cases: accident cases within a period of 2 years, goods sold and delivered within a period of 1 year, land cases within a period of 10 years. Now talking about the land cases, assume for a moment that you own a property and you have title deeds well over 100 years. Some thugs enter the premises, you lost possession. So he has undisturbed, uninterrupted possession for well over 10 years. He becomes the owner. Similarly, you give a premises on rent to some person. At some point of time, he doesn't pay the rent. He doesn't have an agreement either. Or he had an agreement lapse, he doesn't pay at all. He continues to occupy for a period of 10 years. He pay municipal rates and taxes. Then what happened? The question is, even he was a tenant at that point of time, thereafter there is a thing called overtax. So then he becomes the owner. So important thing in regard to a prescription, undisturbed, uninterrupted possession. So if that is to be changed, there must be something called overtime. So I'll tell you again. Prescription ordinance, accident cases, 2 years. Goods sold and delivered, 1 year. Land actions, 10 years. Section 66 application, Primary Court Act 2. What do you mean by Section 66? There is a breach of peace. So for example, somebody forcibly entering into your house and staying there for well over 2 months. You may be out of the country or something has gone wrong, you are not there at all. So now that person can go. Now say for example, if that person is there for 2 months, it's not that easy. So if you come and house stay, now say you allowed him to stay or occupy in that premises, maybe wrong to, maybe thug, maybe but whoever may be, you are negligent. Why? Your own premises, you allow him to jump and you allow him to occupy without taking any steps for last 60 days. What happened? If he is an unlawful occupant even, If he can prove that he was there for last 60 days, he can go to court, magistrate court, file a 66 application, get back to possession. Why? As far as the magistrate courts are concerned, they only see avoid the breach of peace, not to have any breach of peace. So they say, look, we are not interested about your 100 years deed, we are not concerned about the ownership. All what we want to prove is who was in possession for last 60 days. If he was in possession, he may be a wrongdoer, give the possession. So in case anything, now say if somebody forcibly enter the premises and you manage to get the possession, don't stop with them. What have you got to do? It's always advisable. Go for a district court action, file and get an enjoining order, restraining that person interfering with your title. Otherwise what happens? Again and again he can come. Just to explain you. So if you have property, some people entered, forcibly took over. Then anyway you manage within the 60 days, get back the possession back again. But you can't keep quiet with that. Why? It can occur again. To secure your title, it is advisable to go before the district judges or the district court of a relevant area and get an enjoining order, restraining the defendant in any manner interfering with your rights there. So similarly, if a person is occupying for well over 60 days, magistrate will not look into the title deed, he will grant possession to the person who is in occupation. Magistrate only concern is nothing else, breach of peace. He says, look, all what I have to look at is who was in possession for 60 days. I am not interested about the ownership. Then next is defamation cases, 2 years, written contract, 6 years, oral contract, 3 years, mortgage bond, 10 years. Now come back to the question of mortgage bond, that's very important. From the date of the execution of the mortgage bond, and if within a period of 10 years. But if within that period of 10 years time, if he has made any part payment, the prescription runs from the date of the part payment, not from the mortgage, not from the original date of the execution of the mortgage bond. Then checks, promissory notes and bills of exchange, 6 years, but back again to present a check within 6 months. Now say if a check is bounced, 6 years you can file, or promissory note within 6 years, bill of lading 6 years. But if you have a check, if you don't present to the bank to deposit or try to encash, it becomes a stale check, it's a piece of paper. So therefore, check once it bounced, 6 years, but if it is not presented, 6 months. Then in regard to testamentary case, section 545 of the Civil Procedure Code, 5 years, agreement, arrears of rent, 3 years, labor tribunal, 6 months, possessory action, 1 year. I'll repeat it again. If anybody is taken down, you can slowly take it down. Prescription ordinance, now these are the vendors. Number 1, accident cases, 2 years. Goods sold and delivered, 1 year. Land actions, 10 years. Section 66 of the Primary Court Act, 2 months. Defamation cases, 2 years. Written contract, 6 years. Oral contract, 3 years. Mortgage bond, 10 years. But you have to see whether any part payment made. Check, promissory notes or bill of exchange, 6 years. To present a check, 6 months. To file a testamentary case, 5 years. Arrears of rent, 3 years. Labor tribunal, 6 months. Possessory action, 1 year. So those are the things to be done there. Now, next question is, when you draft, so these are the defenses you have, because as I said, as overall chairman of the Professional Purposes Committee, there are quite a lot of complaints, again, especially young lawyers who are less than 5 years in career, unaware of this prescription. They just file action, just to make a quick buck. Then what happens? Other side takes objection. Action gets dismissed. So the lawyer sending a complaint saying that I wasted my time and it got time barred also. This lady knew very well that this action is prescribed and filed action and got so much of money. So be very careful when you are doing. Similarly, when you are for a defendant, when you draft answer or when you draft objection, take up these objections whether it is prescribed or not. Then the next one, when you draft a claim, another matter you have to take into very consideration is section 400, whether state is a party. Why? What is the special in regard to state is a party? There is a special provision when you are suing a state institution. There are certain requirements to be fulfilled. What is the requirement? Section 461 of the Civil Procedure Code says, if a state is a party, what have you got to do? Section, no action shall be instituted against Attorney General as representing state or against a minister, deputy minister or public officer in respect of any act purporting to be done by him or in his official capacity until the expiration of 1 month next after notice in writing has been delivered to such Attorney General. Now the next question arises, okay, you filed action and not given notice. Will the action get dismissed or is the plaintiff fatally bad? Answer is no. Section 461 subparagraph A says, where notice as required, Section 461 has been given prior to the institution action or objection taken up prior to or in the same way no such notice has been given, court shall stay further proceeding of the action for a period of 1 month. Of course, court can order cost. So the different position is, when state is a party, it is mandatory that you have to file, you have to give 1 month notice. If you don't give 1 month notice, action will not get dismissed, but definitely court will abate the case or postpone the case for 1 month, but you have to pay costs. That is the important thing there. The next one is another important thing in regard to the small claim. Now there is a small claim, court has come for 1.5 million, but before that, if there is any action, say less than $1 million, you have to get a certificate of non-settlement, because under the Mediation Board Act, if you have filed action to recover any amount less than $1 million, if the other side takes up the objection that you have not taken up a certificate of non-settlement, action will fail. Then another crucial thing is in regard to the commercial transaction. Very often the agreement sued upon in the commercial high court has arbitration clauses. Now I know one particular instances where a person who purchased a vehicle and the vehicle was seized and finally action was filed. So he went on, he said wrongful seizure, I have paid more than 75% of the amount and the wrongly done damages. Case went on for a while. The senior lawyer who got involved did not look into the fact that there is arbitration clause. Action got dismissed. Lawyer was sued upon, not only steps taken in regard to the professional misconduct, civil action was filed against the lawyer to recover that money. How far successful, another issue, but you have to be careful whether there is an arbitration clause. Talking about the arbitration clause, the case on the point is a famous case, Hotel Galaxy. In that case, it is case number is 1987 1 SLR 5, Hotel Galaxy Private Limited versus Mercantile Hotel Management Limited. 1987 1 SLR 5. This is a very famous case where that is situated at Ibangula Junction or Union Place, now the present Apid building. It was earlier Hotel Galaxy. So this Hotel Galaxy was given on rent to Mercantile Investment. Then they were having their business and running. Some dispute arose. They were ejected from the premises there. Then what happened was, the Mercantile Investment, they went to court, magistrate court, filed a 66 application, asked for an interim order to restore them back into possession. Court at that time, Fourth Magistrate Court, I can still remember the former Supreme Court Judge S.I. Imam, he was the judge who was sitting as a Fourth Magistrate, held at this stage, I refused to grant an interim order. Thereafter they came to District Court, filed action and got an enjoining order, restraining the Hotel Galaxy, interfering with them, and finally the injunction was issued. So on the when they came up in the District Court, initially they granted an enjoining order. Subsequently, I got the opportunity to appear with Dr. Colina de Silva as a junior in the case. And when the case came up in the District Court, court held that there is a vital suppression, enjoining order was vacated. Against that order, they went to the Court of Appeal. Court of Appeal turned the District Court order and said, yes, it is a suppression, but it is not a vital suppression. Now the matter in Supreme Court only, I appeared as a junior counsel, Dr. Colina de Silva. the interesting point is, we went on the basis of suppression of material facts, various other questions. But the judges who heard the case, very well known as well reputed three judges of the Supreme Court, Justice Athukorla, Justice Sarvananda, as well as Justice Tambaya, unbelievably, the area where none of the counsel argued, they looked into, because as at that time these arbitrations were not like, there were no arbitration act at that time. The arbitration was, wording of the arbitration is depending on the contract. Those days there was a famous call, Scott versus Avery. But they look at it in an agreement, whether there is a proper arbitration clause to the effect, whether there is an ouster clause, whether it is say that it is mandatory, that it is to refer to the arbitration. So when our counsels were arguing, mainly on the point of suppression of material facts and the case has not been presented properly, especially I can still remember separate judgment written by Justice Athukorala. He said, leave all these matters aside. District Court should not have entertained the claim in the first instance because there is an arbitration clause. Arbitration clause very categorically states that court has no jurisdiction. It is a conditional precedent to refer the matter to the arbitration tribunal. Based on that, the action dismissed. That's the famous case in regard to the arbitration. So when you are drafting papers in regard to the matters pertaining to the commercial high court, generally 99.99, almost all the commercial transaction, commercial contracts, you very categorically get arbitration clause. So specifically, now of course in view of the Arbitration Act, you are totally shut out. There is no question at all. You can't you can't basically invoke the jurisdiction without when there is an arbitration clause. But having said so, there is one particular judgment, unreported judgment, where it says if there is an irreparable loss and damage occurs in such occasion where court could grant a temporary enjoining order until that arbitration tribunal is formed. So the matters to be looked into. Now the other one is so back again quickly I'll run through, then I come to the main point. When matters to be taken into account when drafting plain, petition, answer and objection, if you are a practitioner in the district court or the commercial high court, number one, jurisdiction, I dealt in detail. Number two, cause of action, that again I dealt. Number three, identify the defendant, I dealt with you. Prescription ordinance, what have we got to do, whether state is a party, what to do. Then the next is in regard to a arbitration clause. Now, having filed the case, now let's look at the practical side of it. Having filed the case, what steps to be taken? Now say you file a district court action, summons issued, enjoining order you obtain. And now what can the defendant do? There are three things, if you are appearing for a defendant, three things you can do. Number one, when a summons is served, enjoining order is issued, notice of interim injunction issued, if you do feel that enjoining order is harmless, not bothered at all, you simply come to court and client says, I am not in a hurry, file a proxy, move for a date for answer and objection. There again, most of these young lawyers make the mistake, they come to court, get a date for objection, forget to get a date for answer. If you are not getting a date for answer, at least get it recorded. Answer to be filed after the order delivered in regard to the application for interim injunction. So that's what we do. But there are enough instances where I myself succeeded. They come, move for a date for objections and go, not a date for answer. If the other side files a motion and asks court to fix ex parte trial, it will be fixed. What is the purpose? Then the second thing is, now this is the first thing. The second thing is, you get the papers in hand, you find one of those categories are falling. Number one, no jurisdiction. They have filed action in the wrong court. Parties are residing in, say, Kaduela or Homagama, they file action in Colombo. You can take up jurisdiction of it. Or divorce case. There is no date of desertion, though there is no date of cause of action. Then you ask for a dismissal. Or action is on the face of it prescribed. Then if you have any of these, or you have an arbitration clause, if you have any of these things, in regard and with all these, any of the defects, if an enjoining order has been granted by court, all what you have to do is nothing to file any, you need not file any paper. Simply go to court, tender the proxy and saying, I am moving court to dismiss this action, give the reason. If it is the arbitration clause, he said, I am just bringing the notice of the Honours Court, clause such and such, the document annexed by them in the agreement shows and the action to be dismissed. Similarly, if it is prescribed on the face of it, you can
So you are getting from the microscope.
Is it okay, Prabha?
Yes, sir, it's okay.
Right. So you have to be very cautious there. So as I said, 3 steps are. First step, once you file, you can go to court. If the enjoining order doesn't bother you, move for a date to file answer objection. Ensure either you reserve the right or moving for a date. Number 1. Number 2, you can take any of those defenses on the face of it. You can say action is prescribed or no cause of action. There is a prescription. It is prescribed. Or arbitration clause you can take there. So court has to either they'll give a date to make oral submission or fix it for written submission and give an order. Now the third scenario is enjoining orders are not given just at a discretion of. It always says once an enjoining order is given, for good and valid reasons enjoining order has to be extended. So the other side has to set out why it should be extended. You can go to court on the returnable date, and if you have any ground on the situation there where you can have this is not a thing to be say for example they are asking certain incident, say for example preventing not to hold the election on a particular day, that date lapsed, then you can say no, this enjoining order is redundant, it is not practical at all, now that date lapsed and there is nothing to extend. So likewise you can take objections are there, so when you offer the defendant. So those are the steps that you could take when you offer the defendant. Now the next question arises, when you offer a plaintiff, you file action. Having filed action, the next step is there is any person, say you filed a case, rent and ejectment against the defendant. While the action is going on, you get to know that he is trying to advertise in newspapers to sublet. Can you go to court? Yes, you can. You can file a petition, an affidavit and get a court order restraining the other side, letting the premises. So just because of you filed action, you are not shut out. That is important there. Then the other crucial thing, very, very often this, especially young lawyers make mistakes on the matter, you file a proxy. When you do file a proxy, the law says very clearly, until it is revoked, it's valid. There are instances, having filed a proxy, we don't get instruction or we don't get fees. Then the question arises, in such event, what can you do? Can you just, I see very often the young lawyers who come to court and say, I have no instruction. That is bad. Because in case they report you, your license will get cancelled. All what you have to do is, specifically now there is earlier the law pertained to that was section 27 subparagraph 2(3)(b), where it was only earlier if the client had the power to revoke proxy with the permission of court. Now it's other way, where the lawyer can do. So what the law says, section 27 subparagraph 3(2)(b) says, if a lawyer want to revoke a proxy, lawyer has to give 1 month notice to the client, inform whatever the reason, you are not giving instruction, you are not paying fees, or you are not coming and meeting me, I can't continue with the case, I want to revoke. Then you send a letter, thereafter you file a motion, get a court order to the effect that my proxy be removed. Don't just getting into a fight with the client. And today, for a drop of a hat, clients are reporting the lawyers and rules are issued. So very, very careful. This is a very noble profession. You have to understand the value. You have to understand that. Don't get entangled with client. If a client doesn't want you, you get out of it. They will be, because thereafter the consequences are far-reaching. So don't get. And also there was a famous case called Attanayaka's case where state is involved. The very senior lawyer, he filed an action for one of the former Supreme Court judge in Mount Lania. On the summons returnable date, he didn't go, he sent somebody else. So the district who happened to be his client, former High Court judge, former Supreme Court judge, sent a letter to the instructing attorney, said, you being a friend of mine, you should have personally appeared in the case instead of standing somebody. He got into unwanted correspondence with the client. result in possession was he got struck off the road. After that he died. So don't ever get involved with the clients unwantedly. If you have any problem, please tell the client, take the brief and go. I don't want even fees, be out of it. Because I have seen not only young lawyers, even senior lawyers get very, very vindictive against the clients. So you don't do that. Clients you must understand one thing. I almost like every Saturday I sit as one of the member of the disciplinary committee. I am the chairman in panel number 1. If against one lawyer, there are 10 lawyers are willing to appear free. So we have reached that level. So you have to be careful, because it is very, very dangerous practicing today there, because you make a mistake, you have your enemies around, you don't know who is with you, who is against you. Be very cautious there. Then next question is, now I think we are running out of time, but I would like to quickly touch Prabha on certain area, because next question is, when you file action, the other thing but you have to look at is statute, but I am going to quickly deal with the statute. That is, I think, very burning issue now. Recovery of Possession Act 1 of 2023. So these are in regard to the applicable lease agreements are concerned. Prior to this act came into, I'll quickly run through, prior to this act came into operation, the law which prevailed was Rent Act number 7 of 1972. The act was totally brought in to protect the tenants. How far it has been protected the tenants? You couldn't, no way a tenant could be easily ejected. There are stringent procedure to be followed to eject a tenant. So result in possession, you see now, classic example I can give you. In Main Street, Peta, it's about 15 purchase land 40 years ago, in the year of 1985, 15 purchase of land, one of my client purchased. He got it little below the market value, because they're adjoining, there's a small 10 by 10 area, a tenant occupied. He was paying only 86 rupees and 50 cents rent per month from that date up to date. So he was occupying for basically 40 years. Even if he paid 100 rupees, say 100 rupees would have been 1200 for 40 years would have been 48,000. We instituted action this year because this client wanted to put a 3-story building and we have to pay 50 million. Imagine, for the whole 40 years he paid only 50,000. The result is that. So in view of that only, this was brought in. But the thing is, I said it in my earlier lectures also. Come back to the question of 7 of 72 is undoubtedly, I used a phraseology, laws delayed, the justice delayed, justice denied. Now the question is, new legislation has come in. I don't want to say, I'll make a quick run through. You can decide whether what I say is right or wrong. My question to you, I leave it you to decide. I'm not going to say anything. Whether it is, there are, this phraseology, two sides are there. Justice delayed, justice denied, justice hurried, justice buried. So it's up to you to decide whether it is justice hurried. I run through quickly the salient features. To file an action in regard to this Recovery of Possession Act 1 of 2023, number 1, it has to be duly executed. That is duly in terms of section 2, and also due stamp duty paid. What you have to do is, they are again talking about the jurisdiction. You can file action where the lease property is situated, or where the lessee resides, or where the action arose and the lease agreement ought to be involved. Now come back to this particular lease is concerned, there is no necessity, it is not mandated to register. But if you look at section 30, subparagraph A of the Notary's Ordinance, registration is mandatory. Registration is mandatory. So no such situation is here. And also what happens here, when you file, there are two instances you can file action. Number 1, when the lease is over, or when, now say, upon the expiry of the period of lease, or refuse or fail or neglect. That is in the first instance. The second instance is prior to the expiry, in the event of subletting or converting some kind of a violation. So what the court do is, on these two occasions, you file plaint and affidavit there. There is no summons here. These like a somewhat like a summary procedure, but this is worse than the summary procedure. What the court do is, decree nisi will be issued. Decree nisi will be issued in the first instance to show cause why the person should not be, why the relief sought should not be given. Now, say, but I ask her, if that person is asking for ejectment or damages, why it should not be given. Then what happened was, of course, there are certain safeguards are there. It says very clearly, there can't be any alteration, eraser or interpolation. That has to be there. If it is done, it has to be done prior to the party sign the thing. Then if the court is satisfied, the danger is, I will just explain you, this is how the summons. Show cause why this dignizer should not be made absolute. Where leave is granted to appear and show cause, sufficient security there. So if the court is happy, however much your case is good, if the court is satisfied with your defense, still entire amount claimed by the plaintiff has to be deposited. And if the court is not satisfied, straight away writ issued. You will be thrown out. Then recently there was a case on this matter where before that I say now what the court can do. So court, once we do that, there is everything is time schedule. Once papers are filed, within 7 days you have to support. Once you support the matter within 7 days, within 3 days it has to be served. If it is in Colombo, if it is outside Colombo, it is within 10 days. Then having served that one there, once you come back, if the court is satisfied, say deposit so much of money within 2 weeks. If the 2 weeks is not given, then another 2 weeks, that's all. So the most dangerous thing is, there is a clause here, clause 11 subparagraph 1, procedure regarding to granting leave and time limit to show cause, as per section 11 subparagraph 1, upon supporting court will enter dignizer in the first instance. In such event, court should grant time not later than 6 weeks from the date of the dignizer. In short, upon the dignizer being served, within the stipulated period, petition affidavit should be filed. Then section 11 subparagraph 2, this is important. Court will not grant any further time to file paper. No exceptional circumstances set out in the act to obtain more time or further time, totally timed. So no discussion at all. Once you say no, there. Now there is a case recently in the Supreme Court. I can give you the reference, SC Appeal 59/2024, where decree nisi was served on a defendant. As at the time of the service of the decree nisi, the defendant was in jail. He was incarcerated. So home people who are at the house has taken the summons, got a lawyer. Lawyer went to prison, got the proxy signed. He came to courts and said, look, my client is incarcerated. I am unable to obtain instructions. Today is the returnable date. I know in terms of 11.1, I have no right to get a date, but I am compelled. Court said, I sympathize with you. My hands are tied. He just straight away writ issued. Against the writ, went to Court of Appeal, Civil Appeal High Court. The Civil Appeal High Court took up the position, well, audi ultra partem, natural justice has to be followed. Even the law has to be interpreted liberally, and therefore set aside the order. Against that, went to Supreme Court. Supreme Court held, of course, very stringently said, section 11, subparagraph 2, very categorically as stated here. 11.2, court will not grant any further time to file papers by the defendant show cause why dignizer should be made. And therefore, court hands are tied. Nothing can be done. So I'm not trying to say, that's what I said, the situation is, of course, we have to bow down, that's the law of the land, we must respect. But the question is, when you are practicing as an instructing attorney, be very cautious. Especially when there are actions, now you know, I read out the judgment to you, when there are actions, especially 1 of 2023, those we call DRE, within bracket S, stringent procedure. If the procedure not followed, is not like an ex parte, you can back it. Straight away person is thrown out. Straight away person is. So you have to be very careful in regard to these cases, because most of the lawyers are not aware of the consequences of this section there. Now talking about that, there are instances where a lot of, because this act is concerned, where there can be lot of malpractice could occur. For example, there is no necessity in terms of this act to serve summons personally. It says registered post put to. That is one. The second thing is, the worst thing is, as at now, the practice we hitherto adopted is, when a person evading to take summons, what do? The fiscal report to court, went several times, unable to serve summons, and therefore reporting that the substituted service should be granted. Court looked into the matter, allowed permission. How did they allow? They will tell plaintiff to swear an affidavit. What is the affidavit, nature of the affidavit? To say that the fiscal has tried to serve, failed, gone several times, reported to court, unable to serve personally, he is in the country and evading, then only paste in there. But in terms of the new law, it's very simple. If the fiscal field, section 9 subparagraph 6, if the process server couldn't serve the degree nisi, he would affish the same in the part of the premises without any further direction. So the judge's powers also have been arrogated to him, and report such service deemed to have been duly served. So today, if some person gets hold of a fiscal and pay some money and tell the person, and especially look back people who are living in condominium units, and even regard the service of summons, registered post, you don't know who has received the registered post. So no, you know, so yeah, so the important thing is, you see, come back to this section, there is lot of area, there are quite a lot of areas are there. Then even in regard to the Court of Appeal or Supreme Court, exactly from the date of the NISI has been granted, degree NISI granted, within a period of 14 days, you have to take steps. Mere filing appeal papers in the Court of Appeal, one, you have to get a stay. Now the danger there is, even in once you file papers in the court, Civil Appeal High Court, very clear that no stay order can be granted without the, no stay order can granted ex parte. Now, it's a known fact, we all know in regard to the stay order, in terms of the Supreme Court rules, in terms of the Court of Appeal rules, where you can get for an emergency, urgent matters, ex parte interim order. No, these are violating all the rules there, where straight away says no, not even the Supreme Court, Court of Appeal can grant any relief without inter partes. Now the other danger is, now come back to the other issue is, assume for a moment if somebody has a lease agreement for a period of 25 years. For some reason he got, action was filed in this nature and he got thrown out within a period of 2 years. He has another 23 years. Now he filed the case in the, he lost in the district court, that's why he got thrown out. He went to civil appeal, failed. Finally went to Supreme Court. Supreme Court holds entire action is bad in law, misled court, wrong orders. What can the court do? Court can't restore him back. All they say very, section says very clearly, even if the order is bad, all what the court can do is can't put him back in possession, can give damages. So you can see the danger in this act. That's what I said it at the commencement. The question of lacuna, but you come across here is very terrible there. So, and also now in regard to the section 839, inherent powers of court, nothing. Audi ultra partem, nothing. And no, this thing says the very stringent procedure followed. So those who are practicing, especially in this area, as a instructing attorney in the commercial high court, district court, if you are representing a client in regard to the falling within the ambit of 1 of 2023, be very cautious. To begin with, number one, like in that summary cases where even here again, there is no wait, don't wait till the returnable date, file papers. If you don't file papers, no time period will be granted. Then the second issue is similarly in regard to the Court of Appeal or Supreme Court, you should know that no, if you are for the defendant, court, if you are for the plaintiff there again no stay order will be issued without the other notice there. So I think Prabha, another 5 minutes more. I wonder whether there are any questions and answers. Thank you for listening to my lecture.
Sir, may I ask a question?
Sure.
Can you hear me?
Yeah, I can hear you.
Ask a question, please?
Yeah.
So what about the Protection of Occupants Act
It is only still at the bill stage, not come yet. Even amendment to the Rent Act, repeal of the Rent Act has come in, but still not there. So in regard to the repeal of the Rent Act also, basically what happens is whatever the protection that the tenant had under the, I don't agree with the 7/72, my personal opinion. I don't agree with the 7/72 which I said the justice delayed, justice denied, and also here its question is to be me a little harsh on the thing using the terminology. This is justice hurried, justice buried. So what more than that? I just told you the example, the judgment recently where man incarcerated. Can there be any? It's like an act of God. It's like a beyond his control. And we are all know as a practitioner going and getting a proxy signed in jail and also getting instruction to file papers for leave to appear and defend is not that easy. So come back to the question of 7 of 1972 going to be totally repealed. The resulting portion of the repeal is whatever the safeguard that the tenants had falling within the rent act, after 1 year they will be out. Back again they will fall back to the normal category. Only thing is they can't come under 1 of 2024 because there are no lease agreements.
Thank you, sir. Sir, also now you said, of course, there's all transfers and leases has to be registered.
Yeah.
But still, for all nowadays, lot of clients, especially with regards to condominiums, they ask for unregistered leases. In such a situation, what is the rights and liabilities of the the tenants under the new act?
Yeah, under the new act, come back to the 1 of 2023, registration is not mandatory. So the question is, you see, when you execute a deed, in deeds has a 3 component: original, duplicate, protocol, and in any event, whether you register it or not, duplicate goes to the land registry. It's a land, and also from the land registry duplicate, they'll even send copies to Inland Revenue Department. Other places are there. So the fact is, to invoke the jurisdiction of this act, non-registration is not a bar. You can. But the question arises when time to come. Somebody will, I'm bound to say this, somebody will take up the objection in terms of the Notary's Ordinance section 31 paragraph 22. This particular lease is not a valid lease because it's not valid. It's not registered. So still that we are not tested that one. That's what I said. Normally when you do special laws, you always ensure to run concurrent with the other laws. Now even 10 of 1996 special, we brought the Commercial High Court Act. Having brought the Act, Civil Procedure Code, things are concurrently going through. Even if you take a worst thing, priority execution, that was like a draconian law. Even in that law, to Priority Execution Act, in that also, although bank as this licensed bank had power to get the mortgages and proceed with priority without invoking jurisdiction, stringent procedure. You have to publish in the newspapers, gazette notification, and that's why even a slightest thing, court grants interim order. Now here, totally safeguards are complete. So district judges, with all respect, district judges' hands are tied. Court of Appeal judges' hands are tied. Supreme Court judges are tied. Because now the courts also saying, we can't give any liberal interpretation. These are special laws, broad, letter to the word, law has to be interpreted. So answer to your question, simple. The registration is not mandatory unless otherwise somebody takes up objection in regard Notary's Ordinance. So those leases are valid, notwithstanding not registered.
Thank you very much, sir. Thank you.
So if it's the notary who's doing the lease agreement,
yeah,
is it okay for the same notary to send the letter of demand in the effectment and also to file the proxy in the matter?
So the question, no, there as far as the case is, there is no conflict of interest. There is no conflict in that way. But I'm saying is there are instances where we do lease agreement, and if there is any violation, now you are sending a letter, not letter of demand, notice to be based on a violation, no. So there is nothing wrong in that because it's based on a violation.
Yes. And also, sir, for the previous question, is it legal for a notary to sign an agreement which is not being registered and not paying the stamp?
No, that's exactly the question I am posing to you. In fact, I was the chairman of the notaries, that amendment committee. This question will definitely arise, but I am shocked and surprised. I mean, completed 45 years in career. To my mind, whatever the laws we drafted, I also drafted 5 laws, Notary's Ordinance, Registration of Documents Act, amendment to this last wills and all that. But we always ensure not to overlap with another law. This completely there, because I am almost certain one of these days, in a case of this nature, defendant will challenge the lease agreement saying that it is violating the Notary's Amendment Act. So the court has to give a ruling.
we file an action in Colombo District Court in English?
No, that is only permissible in the commercial high court only. Still you can't file action in the district court. Commercial high court was permitted now. The language of the court as far as the lower courts are concerned still in Sinhala, as far as north and east concerned it's in Tamil.
Any questions and even English or Tamil is Sinhala?
More comfortable in English and Sinhala.
I have a question, sir.
Sure.
Now, structurally, what is the difference between plain and petition and the content wise? What
See,
would be the difference?
but
Structure and the content, the petition and plain.
I can't, I didn't follow the question.
Petition and plain.
Petition?
What's the difference? Yeah.
No, you're talking about the petition and the plaint. Or?
Yes.
No,
Yes.
the plaint, whenever you use the word plaint, that is the normal procedure, it's not a summary procedure, that's a regular procedure. When it's a summary, there are now certain cases where you file action by way of a summary procedure. When you file action by way of a summary procedure only, where it comes petition and affidavit. When you are filing a normal action, you file plaint and affidavit. The difference, when no sooner you use the word petition, the word comes in now. Say for example, as I said at my lecture also there, you are making you are filing an action to appoint a next friend for a minor. So you file a plaint. But when you are going to ask for a order in terms of summary procedure to appoint somebody as a next friend or a guardian, that is a petition. That is summary. The meaning of a plaint is a regular procedure. The petition is a summary procedure.
Thank you, sir. In addition to the explanation that you gave, sir, structurally is there any different? Content wise?
No. Structurally means the orders are different. Now, for example, whenever you follow the summary procedure, the steps to be taken not normal. Section 377 that you say. Now section 377. Interlocutory orders are issued on that kind of a thing. Now, say in a divorce action, when you file papers in regard to the normal divorce, is different. If you are asking for a divorce on the ground of 7 years separation, that is petition affidavit. So the nature of the documentations are different. No sooner you file papers like petition affidavit, but what comes up in a interlocutory, use the word interlocutory, nice eye, absolute, that kind of things only comes in. Depending on the nature, case to case.
Since there's no questions, with sincere gratitude, we extend our deepest thanks to for joining us today and for generously sharing your wealth of knowledge and professional insight in our content. Your thoughtful clarity and your mastery of legal understanding and the practical wisdom from your experience have truly given today's session. The perspectives you offered will remain with everyone here long after this event concludes. It is an honor and a privilege to have you today, and thank you for enriching our sessions with your presence and your expertise. Thank you very much, sir.
Thank you, Prabha. Thank you for inviting me.